Get ready for the dictation. This petition, filed under Article 226 of the Constitution of India, challenges the action of the respondents in not initiating land acquisition proceedings and not paying compensation in respect of the lands of the petitioners situated in survey number 737 admiring 13 1/2 gutters situated in front of office of the Municipal Corporation, Chennai, as being arbitrary, illegal and improper and violated of Article 14 and 21 of Constitution of India. In response to the rule issued by this court, a counter affidavit is filed by the third respondent, Municipal Corporation, denying the averments made in the affidavit filed in support of the writ petition and in the direction of justifying the impugnant action. It is contended by the learned counsel for the writ petitioners that the impugnant action on the part of the respondent authorities is a clear violation of the fundamental rights guaranteed to the petitioners herein under Article 14 and 21 of the Constitution of India. It is further contended by the learned counsel for the writ petitioners that earlier on 25/1998 and 6 May 1998, the respondent Municipal Corporation addressed letters to the state governments requesting to accord permission to the Municipal Corporation to acquire AC 0.27 gutters of land in serial number 737 and to allot equivalent value of the land to the landowners from the available municipal lands, while referring to a resolution bearing number 725 dated 14 February 1989 passed by the Municipal Corporation. As such, the respondent herein cannot deny the legitimate claim of the petitioners herein. It is also argued by the learned counsel for the petitioners that there is absolutely no dispute with regard to the title to the property, and as such, there is no justification on the part of the respondent authorities in denying the compensation to the petitioners herein. It is also vehemently argued by the learned counsel for the writ petitioners that there is also no delay on the part of the petitioners herein in approaching this court. As such, on the said guard of delay, the petitioners cannot be denied the compensation. Per contra, it is contended by the learned government pleader as well as the learned standing counsel for the third respondent Municipal Corporation that the claim of the petitioners herein is liable to be rejected on the ground of leaches and abnormal delay in approaching this court under Article 226 of the Constitution of India. It is also argued by the learned counsel for the respondents that there is absolutely no proof on record to show that the petitioners herein are the absolute owners of the subject property. It is further contended that earlier the petitioner herein situated OS number 8084 of 1994 before the Court of Principal District Judge seeking injunction against the third respondent Municipal Corporation, and after elaborate inquiry, the said court refused to grant injunction in IA number 1952 of 1994, holding that the petitioners herein failed to establish their prima facie title over the subject property, and subsequently the petitioners herein on 23 March 1997 withdraw the said suit. It is also contended that the resolution number bearing number 725 dated 14 February 1989 passed by the Municipal Corporation was later cancelled, while resolution number 10 dated 9 February 2000 and the same was also communicated to the government wide letter dated 1st March. It is further contended that similarly situated persons, namely one Sajid and three other, filed writ petition number 10,514 of 2001 claiming to the owners of ACO number 0.04 half gattas of land situated in the same survey number, and they also sought for initiation of acquisition proceedings for payment of compensation, and the same was dismissed by this court on 11 September 2008, while this giving opportunity to the petitioners herein to approach the civil court for appropriate relief. In the light of pleadings, submissions and contentions, now the question that arises for consideration of this court under Article 226 of the Constitution of India is whether the petitioners are entitled for any relief from this court in the present writ petition. In the present writ petition, the respondent authorities pressed into service the provisions of the Land Acquisition Act 1894 of acquiring the land serial number 734 and 735 for the purpose of public garden and for construction of houses for low income group near MGM Hospital. It is also an admitted fact that the land acquisition officer passed an award in respect of the present survey number 737 also as long back as on 21 August 1996. It is also an admitted fact that the petitioners herein issued a suit OS number 1884 of 1994 on the file of the principal district judge seeking injunction against the third respondent municipal corporation in respect of the subject survey number. It is categorically stated in the counter affidavit filed on behalf of the third respondent municipal corporation that the said court refused to grant injunction in IA number 952 of 1994, holding that the petitioners herein failed to establish their prima facie title over the property and dismissed the said injunction petition. It is also an admitted fact that subsequently the petitioners herein withdraw the said suit by filing a memo on 23rd March 1997 from the said court. The material available on record further discloses that the petitioners herein placed heavy reliance on the resolution number 725 dated 14 February 1989 passed by third respondent municipal corporation, which was the basis for the letters dated 20 April 1998 and 6 May 1998 addressed by the third respondent municipal corporation to the government. It is the case of the third respondent municipal corporation that subsequently the said resolution bearing number 725 dating 14 February 1989 was cancelled by the municipal corporation wide resolution number 10 dated 9 February 2000. It is also significant to note that identically situated persons filed writ petition number 10,514 of 2001 before this court seeking a direction to the respondent authorities to initiate the land acquisition proceedings for payment of compensation in respect of AC 0.04 half gattas of land in the subject survey number. The said writ petition was dismissed by this court on 11 September 2008. The material available on record manifestly discloses that there is a serious dispute with regard to the title to the property, and as such the said aspect cannot be gone into by this court. Exercise of the powers conferred under Article 226 of the Constitution of India, this court is also not inclined to go into the merits and demerits of the writ petition in view of various factual controversies. For the aforesaid reasons, having regard to the nature of controversy and keeping in view the orders passed by this court in W.P. numbers 10,514 of 2001, the present writ petition is disclosed of, permitting the petitioners herein to approach competent civil court for appropriate relief within a period of 4 months from the date of receipt of a copy of this order, and in event civil court declares that the subject land belongs to the petitioners herein, the respondent authority shall initiate appropriate proceeding under the relevant legislation and pay compensation to the petitioner. It is also made clear that the petitioners herein may claim appropriate damages. Stop. Get ready for the dictation.